Chip Waller. I'm the Waller of Waller and Mitchell. I get contacted from time to time by sellers or buyers about the old saying, quotation mark, buyers beware, end of quotation. This was what the law was in Florida up until about 20 years ago, whenever the Supreme Court handed down a ruling concerning sale of residential real estate. In the case of Johnson versus Davis, the Supreme Court imposed a duty upon a seller to disclose to buyers any matters that may materially affect the value of their property that are not readily observable. These are called latent defects, and there's been any number of cases involving that. The realtors have a disclosure sheet wherein they ask the seller to complete that as far as many aspects of the house, and so that is in addition to the duty of the seller. Also, contracts incorporate this same language that says that the seller has disclosed any matters that may materially affect the property that are not readily observable. So if a seller sells the property and there are undisclosed defects, the buyer has a remedy to sue the seller in order to cancel the transaction. It's called rescission, or sue them for, it's a form of fraud for failure to disclose this information and recover their damages. Unfortunately, many of the sellers may not be collectible, and you may have an empty remedy. So the best advice is to use preventative measures through inspections of the property, to do your due diligence to make sure that the property is sound before you purchase the property, and hire an attorney and inspectors and surveyors so that you don't wind up buying the proverbial pig in a poke. If you would like representation in a real estate transaction as either a buyer or seller, please call me at 727-847-2288. Thank you.